For those of you who are with us this morning, you remember we are addressed by Senator Whitehouse, who's been a staunch supporter of these efforts since he arrived here in Washington. He was very kind to help us arrange for this room this afternoon as we were shifted around due to the State of the Union speech tonight. So let me once again introduce Senator Sheldon Whitehouse of Rhode Island.
Thank you. You may be wondering if I had something else to say. Why the heck didn't I say it this morning when I was here? Well, this is the United States Senate, and we operate under some very arcane but often practical rules. And one of those arcane but practical rules is that when a senator obtains a Senate hearing room for a group, he or she must show up physically during the time that the group has the room. And it actually makes a lot of sense because it helps police or otherwise, you can imagine the efforts to stuff people into hearing rooms. So the rule is if you're a senator, if you've got a hearing room for a group, you have to show up. So I have to show up and you have to listen to me by the Senate rules. But I do want to take this occasion to add just one or two additional thoughts to what I said this morning. Just in terms of some of the details about Rhode Island's experience with justice reinvestment, in 2007, we estimated that Rhode Island's prison population would increase 21%, 2007 to 2017, 21% in 10 years, and that would cost an additional $300 million in construction and operating expenses. So we went through the justice reinvestment data analysis, and we adopted several changes to corrections policy, standardizing the way Rhode Island calculates earned time credits for people in prison who demonstrate good behavior, the so-called good time credits, allowing people in prison to earn good time credits for participation in and completion of educational, job training, substance abuse, and behavior management programs. And the result of this, and we're still at a pretty early stage, as you can see, is an anticipated net savings of approximately $22 million. And that's before the thing has really built out. So I congratulated A.T. Wall, and I recognized him earlier. He's a really remarkable director of corrections, and I want to thank him for his hard work on this and many, many other areas in Rhode Island. I also wanted to recognize Sol Rodriguez, who is here from Rhode Island. We all know each other in Rhode Island, so you got to recognize people. If I were from California and I started recognizing people, we'd be here all day, but Rhode Island, we can do it and move on. And then I'm very glad to see Judge Alm involved here, who was the U.S. Attorney for Hawaii at the time when I was the U.S. Attorney for Rhode Island, and now we're back together in a different set of lives. So I'm thrilled that he's here. The point that I want to make is one about partnership. And I want to use just one example. The Local Initiative Support Corporation, LISC, is active in Rhode Island, and it has been very helpful in supporting our justice reinvestment efforts. Julia Ryan, who is the director of LISC's Community Safety Initiative, I think is here somewhere, and I just want to talk about what they did. They went into Providence and in Pawtucket, two of our urban centers with a lot of reentry happening and a lot of activity. And they went through a structured joint information sharing and decision-making program to help police and corrections, probation, parole officials, and community groups work together better to maintain safety and help people transition on their reentry into, I guess, back to civilian lives. In Providence and in elsewhere, LISC has also increased the housing options for people who are reentering. As you know, a job, clean and sober, and housing are the three legs of the stool for successful reentry, and their work on housing in particular has been very significant. Since 2005, LISC has helped both the Providence Police Department and the Rhode Island Department of Corrections by providing mapping, where they take a look at the territory that they are working in, and they're able to provide visual representations, cross-references for interesting phenomena that focus people on those issues. Things like matching foreclosure challenges and misdemeanor crime in mapping. Mapping violence with reentry patterns, congregation, where groups hang out, troublesome congregating is the phrase for that. But basically, it's unfortunate groups hanging out, and drug sale arrests. And you can learn a lot, and you can focus activity from all of that. So they've been very helpful in that. And then working with the probation officials, they've been a good community partner at taking the folks who are re-entering through the authority of the probation officers and making sure that they get the community support they need for those, the three legs of the stool, that they get access to the substance abuse programs, they get access to the job and job training programs, and they get access to housing. So it's a great program. I've offered and introduced some legislation to increase their grants so they can be more effective around the country. But I think it's just one good example of how the great work that you are doing provides many opportunities for partnering in the communities, and how very rewarding some of that partnering can be. So with that, I think I've said enough to justify you keeping the room for the rest of the afternoon. And I can be on my way, but I don't want to leave without thanking you again for the really, really important work that you do. Particularly the reentry moment is one that has been very, very underserved for all the effort we dedicate to policing the incarcerated population, and for all the effort that we dedicate to policing the general population. That high-risk population coming out of incarceration and into the general population has never achieved the attention that it really deserves. And so thank you and well done.
Well, it's great to have supporters here in Washington who understand what's actually happening in the states and prepared to help us out. And I think Senator Whitehouse has certainly been a new leader in that regard here in Washington, so we're very lucky to have him. In these afternoon sessions, we're going to break out with some more specificity the topics that were discussed this morning in sort of macro analysis. And I'd like to, before I formally introduce the two participants in this panel, just give you a sense as a policymaker, as a politician. Oh, by the way, my name is Mike Lawlor. I'm a legislator from Connecticut. I've been chair of the Judiciary Committee for a long time. I got elected back in '86, so I've been around. But I just wanted to mention two practical questions that have emerged in sort of my career, and to help set the stage for the data we're about to receive, to sort of sort out who these people are. So my first job out of law school, I was a prosecutor. And I worked in the busy urban court in New Haven, Connecticut. And on my very first day on the job, with virtually no training except a law degree and a Soviet studies undergraduate degree, for as much good as that did, I was standing there with a line of people out the door, 200, 300, 400 people a day, with a bucket of police reports, trying to decide what to do with all these cases. And I said, I'm not sure I've got the training. I could take these guys to trial, but I'm not sure I've got the training to sort out who's really dangerous, who's not so bad, who's amenable to treatment, what treatment is available, how can I match these people up. And it was a great source of frustration for me that in my job, where I actually had all the power, I was being asked to make decisions I clearly was not qualified to make. And so that was one of a number of reasons why a few years later I decided to run for the legislature. And since I got there, it's been a fascination of mine to see what, if anything, we can do to provide these resources and this guidance and this training and these options to the police and the prosecutors and judges directly on the front lines. Much more recently in my state, and you might be aware of this, there was a very tragic case where a family was murdered in Cheshire, Connecticut. And the guys who did it had just gotten out of prison, had been sentenced to relatively long terms of incarceration, were out on parole, and as soon as their intense supervision had come to an end, they took them off GPS, et cetera. They broke into a home, murdered 3 people, including a sexual assault, lit the house on fire, and left and were apprehended. And that trial is actually starting right now in Connecticut. And that sort of was as close as I ever want to be to the Willie Horton phenomenon. And in the aftermath of that, as we tried to analyze this, we tried to figure out what could have been done to identify these guys as the potential predators it turned out they actually were. Did someone make a mistake? Was there not enough information available? Were there not enough supervision options available for people finishing their sentences? And I have to say that in my state, that's an ongoing question. What do people need to know in order to sort these guys out? How do you find the relatively small percentage of actual predators? And then what do you do with the much larger group of people who aren't really dangerous and who may or may not be amenable to treatment and may or may not be able to be successful in the community, either in a diversionary program or in a post-release type program? So I don't know the answers to these questions, but the two people on our panel do. The two national experts who can help me figure out what, if anything, I can do as a state legislator. Let me introduce them first, and then first Doug Marlowe, and then Ed Latessa will come up and give us a brief PowerPoint and walk us through these decisions. First, Doug Marlowe. Doug Marlowe is the Chief of Science, Policy, and Law at the National Association of Drug Court Professionals, a senior scientist at the Treatment Research Institute, and an adjunct associate professor of psychiatry at the University of Pennsylvania School of Medicine. He's a lawyer and a clinical psychologist, which I think might be a dangerous combination, but that's what he is. He has received numerous state and federal research grants to study coercion in drug abuse treatment, the effects of drug courts and other diversion programs for drug abusers who are involved in the criminal justice system, and behavioral treatments for drug abusers and criminal offenders. He's a fellow of the American Psychological Association. He received proficiency certification in treatment of psychoactive substance use disorders from the APA College of Professional Psychology. And among other things, he's published over 125 professional articles and chapters on the topics of crime and substance abuse. He's the editor-in-chief of the Drug Court Review and is on the editorial board of Criminal Justice and Behavior, a very well-known publication in the field. He'll be followed by Ed Latessa, who I think many of you also know. Ed is a professor and director at the School of Criminal Justice at the University of Cincinnati. He himself has published over 110 works in the area of criminal justice, corrections, and juvenile justice. He's a co-author of 7 books, including Corrections in the Community, Corrections in America. So those of you who teach can go out and order those for your students. He'll be very happy. He has directed over 100 funded research projects, including studies of day reporting centers, juvenile justice programs, drug courts, intensive supervision programs, halfway houses, and drug programs, the very things that prosecutors and police and others look to decide what to do with different offenders. He and his staff have also assessed over 550 correctional programs throughout the U.S., and he's provided assistance and workshops in over 40 states and the District of Columbia, apparently. So, Doug?
Good afternoon. So it is 27 minutes past lunch. Your insulin levels are at their peak. Your sugar levels are at their lowest point. So I figure I've got about 7 minutes to get your attention and drive home the message. So, and then I'll leave you to Ed. My purpose here is to tell you why to do risk assessment and needs assessment. What's the point of it? And the essence of it is that if you want to have rational drug policy, you have to serve 3 masters, and all 3 of these masters are incredibly jealous. Each master demands your unabiding concentration, your unabiding loyalty. And if you serve one master and offend the other 2, your outcomes will be as bad or worse than if you didn't serve that first master. So who are the masters I'm talking about? Well, first of all, what do we do when we serve these masters? We have a whole continuum of dispositions, and you were mentioning them right earlier, for dealing with offenders in the community. To the left, we have pretrial diversion, pre-plea diversion programs, sometimes called administrative probation or non-reporting probation. The problem with those pre-plea programs is that people very often don't meet the conditions or show up for treatment. So we have something called probation with teeth, also called probation without verdict, disposition without judgment, excuse me, where individuals are required to plead guilty to the charge. The guilty plea is held in abeyance while they complete a term of treatment and other supervision conditions. If they satisfy those conditions, the charges are dropped and the record is expunged. We then have judicially managed drug courts, which I call diversion with bigger teeth, because the judges are managing the diversionary opportunity for these offenders, and they are meant to bridge treatment and criminal justice supervision. To the right, we have intermediate sanctions, which are sentences in the community to dispositions instead of jail or prison. So military-style boot camps, day reporting centers, correctional housing, home-monitored detention. These are intermediate punishments in the community. And then to the right, we have incarceration, jail, or prison as a response to crime, drug-related crime, and the like. Now, as you move from left to right on this continuum, the cost of these interventions go up exponentially, with the greatest cost being associated with incarceration. At the same time, as you go from left to right on this continuum, the risk to public safety goes down, at least while the offenders are under the jurisdiction of those programs. Now, we have heard that the war on drugs with mandatory jail sentencing and prison sentencing was a failure, but that is not entirely true. In fact, the war on drugs contributed to a reduction in then rising crime and violence rates from the 1980s. About 25% of the reduction in crime and violence is attributable to mandatory sentencing. To make matters most complicated, the effects on the functioning of the offenders themselves, substance use, mental illness, employability, family functioning, follows what we call a curvilinear function, where the best effects are for programs in the center of the spectrum that merge treatment with correctional supervision, and the worst effects are at either extreme. Think of Goldilocks and the Three Bears. Things can run too hot or too cold, too hard or too soft. You get iatrogenic effects, which means people get worse if you are either too lenient or too punitive. So drug policy is a very simple task. Criminal justice policy is a very simple task. All you have to do is balance these three masters that are always in direct competition with each other. How you do that is risk and need assessment. Risk and need assessment tells you who goes where to give you the best bang at the least cost and the least risk to public safety. Who should be in prison, who should be diverted, who should be in a judicially monitored program. Now, I tend to be a rather pessimistic guy. As those of you who know me, I tend to focus on the negative. So I'm going to start off with sure strategies to shoot yourselves in the feet, and then to wait till your foot heals, and then shoot yourself in the same foot all over again, which has been essentially the message in drug policy and criminal justice policy in this country. The first thing you can do, an absolute strategy, absolute recipe for failure, is to serve one master. So you have a prosecutor or a judge or somebody in a jurisdiction that runs on a law and order platform. There's a case in Cheshire, Connecticut, where these men come out of prison, they kill this family. We need to keep those SOBs in jail forever. We need mandatory sentencing. The problem is, you remember Cheshire, the Cheshire cat in Alice in Wonderland was always pointing you in the wrong direction. And so you could easily make the mistake of taking that one case and going too far in the wrong direction. You will, in fact, reduce crime and violence rates if you incarcerate everybody. You will. However, you will jack your correctional costs through the ceiling, you'll destroy the individuals involved, their families, and their communities, and then you'll get into a budget problem, which we're all experiencing now. And then to deal with the budget problem, you'll say, no, we're going to serve the cost master. We're going to move everybody out of the institutions, out into the community. California tried that in something called Proposition 36, where they moved everybody out into a probation-supervised treatment program. Crime rates went up in California. In other words, if you focus only on cost, you will drive up public safety risks. If you focus only on public safety, you will drive up costs. The next sure strategy for failure, and I think I just hit that in the wrong direction, is focus on the offense rather than the offender. Most sentencing in this country, or I would say just about all sentencing in this country, is based on what you did. Is it a felony? What class felony is it? Is it your first felony, your second felony? What's your criminal history? In fact, the offense category, while being predictive of outcomes, is much less predictive than who the person is, the nature of the offender themselves. Now, it doesn't matter anymore about the nature of the offender. If your sentencing guidelines say you have determinate sentencing and you get a sentence based on what you did, then who the person is irrelevant. It almost doesn't matter if they're an addict or mentally ill or homeless if that is not a guided factor in sentencing guidelines. And when we moved in the 80s, the first thing we did was strike offender characteristics from our sentencing statutes so that we would focus only on the offense. The next thing you can do to absolutely ensure failure is equate risk with violence potential. We've been using the word risk here as if these people are going to go into someone's home and kill an entire family. When your probation department gives the LSIR, the level of service inventory, to an offender, or the COMPAS, or the Wisconsin, the risk tools they use, those risk tools, if they say that somebody is high risk, that does not necessarily mean that that person is violent. In fact, it probably doesn't mean that that person is violent. When my wife was pregnant with our second child, she was considered to be a high-risk pregnancy, okay? That did not mean they were afraid she was going to go out and kill somebody, all right? Although during some of those hormone surges, I worried about that. What it really meant was that she was at risk for a negative outcome. She was at risk for a failure. She was at risk for negative side effects. What it means is a bad prognosis. That's what those tools measure. If you go to your doctor does two things. Diagnoses you, and then says, what's your prognosis? How likely are you to respond to a standard intervention? That's what risk means. They're poorer prognosis cases. So if I was using drugs before, I'm going to keep using drugs. If I committed thefts before, I'm going to keep committing thefts. If I was violent, I'm going to keep being violent. And by the way, best predictor of violence is a history of violence. And there are violence tools that assess violence potential. There is definitely a way to assess violence potential, especially people in custody environments. It's not hard at all to identify the predators because they probably were predators while they were in the custody setting. So in fact, it's not a hard case to flag. The next mistake that you can make, an absolute recipe for failure, is identify the cases. I got this once. I was talking to a probation organization, and one of the guys raised their hand. He says, Doug, we know this already. We do risk assessment when people come into our facilities. We identify the high-risk offenders, we screen them out of the treatment programs, and then we put the low and moderate-risk offenders into the treatment programs. And I said, now, you do realize you got that backwards, right? The purpose of risk assessment is to screen people into more services. The definition of low risk is the person is a good prognosis. They're going to get better anyway. Why would you take all your low-risk cases that are going to get better anyway and target all your services to the people who are going to get better anyway? That wastes money and has no effects. You target your services to the high-risk cases, not to the low-risk cases. The next mistake you can make is to focus on risk and ignore needs. Now, needs are similar to risk in that they predict a negative outcome, but needs are clinical syndromes, dysfunctions that offenders have, that if you treat them, the risk of criminality goes down. And if you don't treat them, the risk of criminality does not go down, okay? A perfect example is addiction. Now, I didn't say the person was arrested for a drug crime, because many, if not most, drug offenders are not addicted. But among the ones who are addicted, there are no studies showing reliable outcomes unless you treat the symptoms. For the abusers, you're not going to target your treatment services to an abuser population. You're going to target it to your addict population. I'm here to tell you there's no reliable data out there that you can reduce recidivism in a truly addicted population if you don't treat the addiction. Same thing for mental illness, same thing for homelessness. Not true for all problems that offenders experience. For example, offenders that have lots of problems that don't matter from a criminogenic standpoint. We used to think that we had to improve the self-esteem of offenders. For example, if they felt better about themselves, they would stop committing crimes. What they found after study is they wound up with offenders with better self-esteem. In other words, you could impact a needs factor, but it was irrelevant. In other words, offenders don't commit crimes because they have low self-esteem. They have low self-esteem because they commit crimes. They're in and out of jail. They're unemployable. Their family won't talk to them. Everyone looks down on them. Of course they feel bad about themselves. When they improve their behavior, you could expect their self-image to improve as a result. So some things cause crime and some things are a result of crime. Well, if those are the sure strategies for failure, then what are the recipes for success? The first is to focus on offender characteristics, which means prognostic risk separate from risk of dangerousness. The first thing you want to know is the person dangerous? If they're dangerous, they need to be in some sort of structured at least potentially institutionalized environment. The next thing is prognostic risk. Most of the prognostic risk tools out there are all very good at predicting risk of failure on conditions. They're not excellent, they're not perfect, but they do it significantly. Why? Because they all base their decisions on the same things. They base their decision on age of onset. They base their decisions on how many times the person failed before in treatment, because the best predictor of the future is always the past. If you failed in treatment before, you failed on probation before, you're a prognostic risk the next time around. The other thing is your criminogenic needs, which are the disorders, the dysfunctions that you must treat in order to impact crime. Now, the only way that this makes any difference at all is if they are incorporated in your sentencing guidelines and your supervision guidelines. If the sentencing guidelines say that risk and need is based on a matrix, severity of the current offense and number of prior offenses, and risk and need factors are only considered for what we call upward or downward departure, which means only if there's something extreme can the judge deviate from that sentencing guideline, then it's irrelevant what their risk and need are. It can't affect the disposition. So sentencing guidelines need to incorporate risk and need, validated risk and need assessment in the sentencing guidelines. Number two, revive the pre-sentencing investigation. We used to do risk needs assessments prior to sentencing. We stopped doing it when we moved to determinant sentencing because it didn't make any difference. If the person is going to get whatever sentence the severity of their crime requires, then who cares if they're an addict? When they go to prison, they'll get some addiction treatment in prison. Maybe when they go to probation, they'll get it. But it wasn't relevant to disposition. The PSI, the pre-sentencing investigation, has essentially died in many parts of this country. It needs to be brought back as part of a sentencing disposition. Target your interventions to the high-risk, high-needs offenders. Those are where you get the best bang for your buck. Divert out your low-risk, low-needs cases, probation supervision, those kinds of dispositions, and take your high-risk people into those intensive, court-monitored, intermediate sanctioning type programs. That's who's suited to those programs. Develop a presumption, not a requirement, but a presumption that if there is a disposition the evidence suggests should be better for this offender, the presumption is that the judge or probation will apply that intervention, that sentence, unless there's a good reason not to. Make it something that we assume that our judges will make their decisions based on what the research tells us is likely to improve outcomes and contain costs, and have that be an explicit requirement in sentencing determinations. Right now it isn't. Judges can say, I understand that the best disposition for him would be this. It would be cheap, it would be effective, I don't care. I want to give a message to the community anyway, and therefore I'm giving them this disposition. Now, they may still have that discretion, but they should be required to say out loud that that's why that decision is being made. It's being made for reasons that don't relate to the likelihood of a positive outcome for the individual. And publish sentencing and supervision trend and outcome data so that everybody can evaluate the performance of their criminal justice system, their probation agencies. What are the recidivism rates? What are the proportion of high-cost sentences divvied out to low-risk populations? How many addicted, non-criminologically involved individuals were sentenced to jail in this particular jurisdiction? There is no reason those data could not be published and available for analysis and for public comment and reaction to it. Those are public events. So I think I'm just about, and performance-based contracting, probation departments and other organizations, their contract should say, this is the amount of money you get for a certain level of performance. You're guaranteed 90% of that contract, but you can get 110% of the contract if you meet benchmarks for recidivism reduction, avoidance of jail beds, and the like. It's very simple to apply contingencies to the criminal justice system the same way we apply contingencies to our clients and to our employees and our supervisees. So thank you. I think we're going to have time for question and answers afterwards. Is that right? Okay. Thank you very much.
I'm Ed Latessa. And I always liked following Doug because he's one of the few people I know who can sue himself for malpractice. I'm going to follow up a little bit on some of the points Doug made, and since I'm a professor, I always feel the need to show some data. So I'm going to do that and try to get through this fairly quickly and talk about really the importance of offender assessment and give you some of the, kind of what we know and why, and kind of sum it up at the end. And I thought about it. I think the fact that we start by talking about assessment for this summit is appropriate because it's really the place we start. If you think about it, how important, whether you're taking your car in to get fixed or whether you're going to a doctor, the first thing you want is an assessment done. You don't want the mechanic to say, well, we'll just tear it apart and figure out what's wrong with it and send you a bill. You want them to hook it up to the computer. You want them to ask some questions. The same with your doctor. So assessment's really the engine that drives effective correctional programs. If you're not doing good assessment, you're not doing it well, the chances that you're going to have effective correctional practices go way down, whether it's in the community or in a prison. Even in a prison, we sort folks out. Let's see. Why is it so important? Doug talked a little bit about our need to not only guide risk management, risk management, but also risk reduction. Helps identify who to target. A simple way to think of what he called the risk principle is, if half of the people that come out of prison never go back again, which half are we worried about? Well, we're worried about the half that do. And that's really the risk principle. That's where we want to put our energies. We want to focus on those individuals with the highest probability of continuing their behavior. What to target? He talked about criminogenic needs. One thing we haven't talked about is the fact that assessment can help us reduce biases. We want to treat individuals fairly. We want to base it on objective criteria of risk, not on race or ethnicity or gender or other kind of extra legal indicators that often work their way into our decision-making processes. Assessment, while it doesn't eliminate that completely, it helps us structure those decisions a little better. And of course, we've talked about utilizing resources. And lastly, I think with the newer generation of assessment, it's not just about identifying who's high risk or low risk, but can we look at that individual at 6 months and at 12 months and at 18 months, in some cases 5 years down the road, if they're incarcerated, and find, has their risk gone down? For those of you that aren't all that familiar with actuarial assessment, I thought I'd just show you a brief chart. We've developed a new assessment tool in Ohio, and this is basically the outcome of the data for the risk assessment. And you can see here low-risk individuals in this case. When we're talking about low risk, we're talking about individuals with about a 9% failure rate. So if you have 100 offenders that are low risk, 9% will fail. We don't know which 9. But we're pretty sure that we're not going to exceed that rate, assuming the assessment was done well. At the high end, we're talking about 70% failure rates. Okay? Now, if you look at this chart, it's pretty easy. The first two groups, if you were betting, you'd bet on them. You'd win most of the time. On the other two groups, of course, you'd lose most of the time. But these are the individuals down here in these higher ranges that we're really most concerned about for public safety. Okay? This is some data from Ohio from a study we did a few years ago. Doug talked about the fact that targeting low-risk individuals is a waste of resources. It's not just a waste of resources, it's harmful. In this study, what we found was those red bars, that represents how much worse low-risk offenders did who were placed in those programs. These were residential programs. Here you see the same programs, but the treatment effect for high-risk offenders. Okay? So most of the programs had an effect for high risk, but for low risk they didn't. And you'll note there were some programs down there that had no effect for anyone. All right? Does anyone know what the scientific term for that is? Shitty program. That's a scientific term for that. That study was done in 2002. In 2009, we're about to finish up a replication study 21,000 offenders, 63 facilities, included both offenders coming in and coming out of the system. What did we find? Low-risk offenders, 6% increase in recidivism when we put them in those programs. High risk, 10% reduction. Same basic effect as the first study, but a bigger study. Now, the good news is we have programs in Ohio that are having a significant effect with high-risk offenders. Those are the people we want to focus on. What to target, again, Doug talked about those factors. I haven't listed them all out, but I want people to understand that one of the reasons, by the way, a lot of programs fail, in my opinion, is they either don't target important criminogenic risk factors, or they only target one or two criminogenic risk factors. When we look at that research, we have identified, we know what the strongest predictors are. Antisocial attitudes, hanging around with the wrong folks. Your mothers all knew that. That's why they worry about who you hung around with. Family, lack of family and social support, substance abuse, education, coping skills. But let me say this, you're not high risk because you have a risk factor. You're high risk because you have a number of risk factors. And the easiest one to understand is employment. Employment, if you're a parolee or a probationer, you're unemployed, that's a big risk factor. But it's not a big risk factor for most of you. If you lost your jobs, you wouldn't start selling drugs or mugging people. You'd go find another job. But if you're unemployed and you hang around with people who think it's okay to do these things, if unemployed and you say things like, I'm not going to work for $10 an hour, I can make more money in a day than you make in a month, then being unemployed dramatically increases your risk because you have 40 hours a week to do nothing but get into trouble. But we sometimes come at it from a very narrow perspective. Some things to remember, summing up. First of all, there's no one-size-fits-all assessment. There are, as Doug mentioned, there are tools that can look at violence. We know there are special populations, like sex offenders, for example, that require some separate types of assessment tools. So as you're designing your assessment system, you need to look across those populations. The purpose will vary. For example, with pretrial. You're not just looking at risk, you're looking at things like failure to appear. That can be something that you also want to predict. Some different indicators there that might come into play. Second, actuarial assessment is much more accurate than clinical assessment. We've known this for many years. There's no question that taking an actuarial, a well-designed, normed, validated instrument can improve our prediction of risk. But there's no perfect assessment. We're still going to have those error rates. Good instruments can get up to 70%. 70%. We're still going to make mistakes. We're going to have false positives. We're going to have false negatives. People have to understand that. And I don't think the science is ever going to get us much higher because we're talking about human behavior and it's just too difficult to predict. Assessments guides decisions. It doesn't make them. We hear a lot of folks say, well, you know, these tools are telling us what to do. They're not. They're giving judges, prosecutors, probation departments, and others information. But at the end of the day, the professional's still going to use that information. And lastly, I get asked a lot about, you know, which tool should I use, which one's better, which one does what. My advice is that which tool you use is a lot less important than how well you use it. We tend to take assessment. We've been doing assessment for a long time, by the way. 1928, the first actuarial assessment tool was developed. The problem is what happens is we have departments and agencies that fill them out and shove them in the files and never look at them again. It's not driving what we do. And so it's really a question of being serious about assessment, making sure they're done well, make sure they're reliable, making sure that we're trying to do the best, what's best for the public as well as for that offender, in which case we'll be able to achieve some of the goals, I think, of evidence-based practices. All right. Did I make it? All right, good. All right, thank you.
So we have a little bit of time for questions. Please feel free to start it off. In the back there.
I don't know if I can remember this because I thought about it with the first speaker. This recent Supreme Court decision whereby a lot of different interests can now influence potentially elections scares me the most with the thought of local judge elections, where you might publish information about their sentencing patterns, etc., and these special unique cases could be used against them in an election time. So I'd like any comments you might have on whether, and maybe not dealing with the recent decision, but that whole issue about judges being elected and how additional information and data could actually be turned against what we're all trying to achieve.
Everybody heard the question. It had to do with publishing sentencing data. First of all, I'm from Pennsylvania, from Philadelphia, where we make judicial elections the most horrible thing in the world. I mean, you know, one of the questions is, should the judiciary be an elected position? It's a whole nother conversation for another day. But the way it works now is that one case that makes it to the newspaper decides the retention decision for a judge. And nobody knows about the other 10,000 cases that went before that judge. And the judge can try to explain himself or herself, try to get some people out there to explain away that case, but you're pretty much done. Unless somebody is analyzing judicial information and giving report cards to judges on their sentencing practices so that when an aberration like that comes up, it is seen as the unusual case, not the typical case. See, we make decisions based on the rare but catastrophic event. All our decisions follow that. So judges will actually be protected if we publish and analyze independently sentencing data. We're doing that in Pennsylvania now because judicial elections are such a mess in Pennsylvania, so that the Sentencing Commission is publishing the sentencing records. The universities are doing research on them, and the public can go on and find out how often this judge applies a jail sentence when an alternative disposition was available, when the guidelines would have permitted it. So, I mean, that's how we should be making our election decisions.
Further questions in the back there? Sorry.
Professor Latessa, you've written some about the harmful effects of incarceration. If we're going to get our incarceration rates in this country down to levels of other industrialized countries, we're going to have a lot more alternatives to incarceration. Should we argue that not only drug offenders or the mentally ill, but all offenders need to have alternatives unless they have to be in prison? And what can we base that argument on?
Well, Doug made a point that I think it's worth thinking about, and that is, seriousness always trumps risk. We just have to recognize that if you commit a violent crime, if someone's injured, someone's hurt, it really doesn't matter if you're low risk on an assessment tool. I mean, and so, that has to factor into the decision. But I think it's clear from the data that we incarcerate many more people than we need to. We keep many of them too long when they certainly don't pose a risk any longer. I think assessments I always say assessment's necessary but not sufficient. As you've got to have a good assessment process because you have to sort these folks out. But you have to have the alternatives. You have to have evidence-based programs. I mean, we've developed a lot of alternatives in this country, but a lot of them are also harmful. They're not effective. I mean, we can take the example of boot camps. We have no evidence that these kind of programs are having much effect on offender behavior. So I think as we work through the summit today, I think it's putting these pieces together, starting with assessment and moving into what are effective programs and what do they look like. And it's just an example with the risk principle. There's two reasons we think we get the negative effect. One is we put low risk and high risk offenders together, right? And so the social learning is the opposite of what we want. We would never put our own children in with a group of high-risk gang members, and we do it all the time in the juvenile justice system, the adult system. And the second reason is because we disrupt what makes them low risk. We take them out of their job and their home and their families, and they're low risk for a reason. And so we have to look at, we can't just create alternatives that aren't going to address some of those issues, or else it won't solve the problem.
You know, if I could just follow up on that question, because I thought I heard both of you say the question was about wouldn't more resources be good in terms of alternatives, but I thought you both sort of stressed the point that maybe instead, or in addition to that, a reallocation of existing resources, shifting them away from the low-risk people and reallocating them for the higher-risk people. So it's not necessarily more is necessary, it's just maybe reallocation. Is that correct?
I think a lot of our criminal justice and correctional policy has been irrational, exactly the way you're suggesting.
Thank you very much, by the way, for that.
Yes, you're welcome. we systematically put our resources into the wrong cases, and we systematically put our expenditures into the programs that have the least effect, and systematically deny resources to the programs that have the better effects. Now, I am not suggesting that jail and prison doesn't have a place here. It absolutely does. Thank God we have jails and prisons, because there are people that need to be there. And there is also some curative potential if they're used appropriately. In other words, like the graduated sanction, the HOPE model, the drug court model of flash incarceration, graduated consequences, needs to be part of this continuum. So I'm not saying get rid of jails or prisons, but when they're 80% of our response, then what we're doing is using a sledgehammer to drive in a thumbtack half the time, and we're wasting tremendous resources. I think reallocation is exactly the right answer. That's exactly the direction that we need to go. We don't need new resources. We need to start using them wisely.
Someone over here had a question, or? Yes, I'm sorry. Yes.
Hi. I had a question, following up on Dr. Marlowe's point about probation and incentivizing probation contracts in order to encourage good outcomes. Do you know of any jurisdictions where that is already being done?
I don't know the performance-based contracting. I don't know it in the context of probation, and probably the people from Pew could probably answer that better than I can. It's being used a lot in the contractees with probation, the treatment agencies that are serving the criminal justice population. Delaware just did a statewide study. We actually did the research on it, where they were holding the treatment programs. They would get beyond their contract if they could keep people in their program for 30 days or more. And you may say, well, gee whiz, what's the big deal about that? Well, because it's rare that you keep people in treatment for 30 days. And so they actually incentivize them to keep them in, provide evidence-based practices. I don't know if it's being done in probation. There's absolutely no reason why it couldn't be. And in fact, I would argue that it should be, that probation, like any other business, like any other organization, should be funded based on its productivity, on how well it does its job. And to the extent that they keep people showing up for appointments, giving drug-free tests, not getting revoked, they should be rewarded for that. I don't know if there's any examples of it.
I think we have time for one more question, because we're up against the final time. So you, sir, right here in the front. Our man, sorry.
That we used to do things off of offenses instead of looking at the offenders. Can you give examples, or do you know of places where they're looking at offender characteristics instead of offenses?
Yeah, what I'm says when we moved from indeterminate to determinate sentencing in this country, it became irrelevant to do a pre-sentencing investigation because it was a matrix model sentence. In Hennepin County, I just completed a study in Minneapolis where all arrestees on drug and property calendars got a risk and needs assessment, which then said what an appropriate disposition would be. A couple thousand cases went through. What the evidence is suggesting to us is that, first of all, it predicted failure on conditions exactly, in a significant way. But individuals who got the appropriate disposition, it's similar to Ed's findings. If you get the right disposition for your level of risk and need, recidivism goes down. If you get a disposition that is too intensive, recidivism goes up, outcomes go down. In other words, it's like Goldilocks and the Three Bears. If you give people too little, they get worse, and if you give them too much, they get worse. And so it's the just right is the issue. We just finished the study. It was just published by their 4th Judicial Department. I didn't publish the study. It's a small study. It's one study, but it's moving in that direction of saying that the offender characteristics don't control. I agree with Ed. You don't make all your decisions based on the individual, but that becomes a permissible thing to consider in going up or going down within the range. That used to be the law. That used to be the way it worked. And then we went too far in the other direction. It became irrelevant. Now we've got to put it back in.
Well, thanks to both Doug and Ed. We're time for our second panel to begin, but